I got the whole world cooking up.
Peace community, peace community. If you're new, welcome to the community. If you are part of the community, welcome back. I like to give a special shout out to Snatch Investigations, Angie Snatch. Salute to you, Queen. You already know. I love all the work that you've been doing since sometimes that we were sharing a little information when we was dealing with the R. Kelly case. And, we was dealing with a little knowledge with the superseding indictments and stuff like that. So salute to Angie Snatch Investigations for her good work. I see your channel's doing great things. Salute to you, Queen. So anybody that's viewing this stream, make sure you are subscribing to Snatch Investigations, because this is what good channels that we get a lot of our updates from. And when I was covering this case, like a lot of certain content, certain creators that I was working in conjunction with, or just sending some knowledge and some things that I got to. And Snatch Investigations, she's a person that's most definitely about her business. So I salute to her. Yeah, this is the Brother Polight 12-3 court hearing. I know a lot of people was wondering about the court hearing. I haven't been on the case as much, but I am going to listen in with Angie Snatch with Snatch Investigations, and we're going to check out this court date too as well, because we want to make sure we understand everything. Brother Polight, if you have been under a rock or you don't know and aren't privy to what's going on, Brother Polight was arrested and charged for the sexual assault of his girlfriend's 14-year-old daughter while he was in Miami, and they were in Miami, and he ended up taking the daughter allegedly to another hotel where the sexual assault allegedly happened. So we are going to get into this court date. Salute to everybody. Make sure you're dropping your likes on the way in. Make sure you're subscribing to One Community, and make sure you're turning on the notification bells. Let's get it.
Nobody's talking yet, but I'm pretty confident from their paperwork. I'm less confident. I'm actually just waiting for the response. I'm interested in what David Torres is going to say, how this is going to play out. Put it on speaker.
Unmute. All right, we are on the record. Good morning, folks. My name is Judge William Altfield. It is my honor to be serving as your circuit court judge. This is Division 20's calendar. I am covering a couple of cases. Judge Cruz will be coming on at 9:30, which is the start of her calendar.
Can you hear the judge?
That were specially set for today. I'll start off with David Santos Munoz on page 5. And counsel, please state your name for the record.
Good morning, Your Honor. Nicole Gristy on behalf of the state of Florida.
And good morning, Judge Nathan Gale Brown, Assistant Public Defender for Mr. Santos Munoz.
This isn't Polight's case yet, guys.
Your Honor, I can address some issues. I know we're special set for trial on Monday. Mr. Gale Brown and I have been diligent in ensuring that all the depositions are taking place. We have done one deposition of one of the minors earlier this week. That deposition went over.
Good morning.
Good morning. At least due to technical issues and interpreter issues. That deposition is going to be continued today at 4 p.m. in agreement with all parties when our schedule is open. That shouldn't take any more than, I think, 15 to 30 minutes.
This is live. This is going on right now. We're waiting for Polight to be called.
We will get that done. However, the defense did file a motion to suppress the defendant's statement. I believe, if I'm not mistaken, either
your
Tuesday
screen
or
is buried.
11:30 at night. And then subsequently the day after, I filed my Williams rule, which I had notified the defense that I was going to be filing, and all the reports on that all the reports for the basis of that Williams rule motion was turned over to the defense over a year ago. So that's the issue, Judge, that we're having. The state was going to rely heavily on the defendant's confession post Miranda in the trial, and the defense filed the motion to suppress, and I believe that we need more time to respond to that. It's extremely important in our case in chief that we're able to rely on that, or at least for impeachment purposes if the defendant takes a stand. This is a case involving 3 15-year-old girls who are now around 16 to 17
His
years
is
of age.
coming up soon. There's
One of
one
them
other
is
hearing
not,
right before his, and then
her
it's
mother
coming
does
up.
not
But yes,
want
this
her
is
to
going to be a
testify.
reporting
And I
hearing,
told Mr. Galen Brown that I
which
would
is
call
kind
you
of like a
ready
status hearing.
to try the case on Monday if we're not given the continuance without that victim. So we have two victims to go forward on. The issue, Judge, is that with the motion to suppress and the Williams rule, that's going to involve witnesses coming in and testifying. And
No problem.
think
Good
we're gonna be
morning,
ready. I think
everyone.
if we get a short, maybe, I was thinking a week to 2 week continuance, but then we're getting up against the holidays. So I think just like the first week of January, I think we'll be ready to try this case.
Hey,
Let me hear
lady.
from the defense.
Judge, yeah, with respect to the depositions, what Ms. Garcia has said is accurate. The one thing I would add to that is that there is one officer that I've been trying to depose. It's Lieutenant Roche, who I believe was involved in a forensic download of my client's cell phone. I didn't anticipate any issues with that. However, I recently found out that he is actually out of state. He had terminated his service. So I believe we haven't been able to depose him this week. I was hoping to have that done today as well. I believe from what Ms. Garcia has said that he is available on Monday, but that is a deposition we have not been able to take.
All right.
That is correct, Your Honor. I have reached out to Lieutenant Roche. I think the first time I heard that the defense was trying to depose this witness was earlier this week. I reached out. I was able to get a hold of him out of the state. Was in Alabama. He is willing to be available for deposition on Monday. The issue is that is a witness that we are going to be flying in for the trial, and we will be relying on him for the trial.
Okay, well, first question the court has is why did the state wait until, I think it was November 30th to file your motion to suppress? Knowing that this was a specially set matter and no further continuances were ordered at that time.
I'm sorry, Judge, that was for the defense?
Yes, you filed a motion to suppress.
No, I
a couple of
understand.
days ago.
I thought I wrenched you
Yes,
up.
Judge. I've been trying to take depositions of the alleged victims in this case. Those are the main witnesses, obviously. And
What does that have to do with wait, you're talking about a motion to suppress a confession or a statement. What does that have to do with your late filing of a motion to suppress?
Judge, the main evidence in this case comes from the alleged victims, of course. And this is it's not a case where there's extensive written statements from the alleged victims. There are statements, but there's not video statements by them. And so, generally before I file motions like this in a case, I want to have that testimony. Obviously these depositions got delayed in this case, but that had been my goal, and that.
Let me go grab my
because
coffee.
they
I'll
were
be right
delayed,
back. Okay.
That wasn't something I was able to do, but that it was filed earlier this week.
All right. And the next question is why did the state wait until, I don't know, what was it, a couple of days ago as well, to file your notice of intent to rely on 404B?
Your Honor, I just want to clarify something with the depositions. The deposition of the witness who, in regards to the motion to suppress, and then I'll address the question from the court. The deposition of the witness who interrogated the defendant and got the confession from the defendant, that deposition from my notes was taken back in April of 2021. So that was available to the defense back in April. With regards to the Williams rule, I was out last week, out of the country. It was something that I tried to do prior to getting out of the country. I unfortunately could not file that in time, and that is an issue. That is something that I did, Your Honor, and I will admit to that. What I will say though is that the standard for whether it's prejudicial to the defense I think the standard is whether it was prejudicial to the defense that the state filed it so late after the 10-day limit prior to trial, Judge. And I would argue that all the reports that we are relying for a motion for a notice of intent to rely on Williams rule was turned over back in February of 2021. I believe that they have had it for at least 10 months at this point, Judge. I have been speaking to Mr. Gayron explaining that I will be filing the Williams rule, and unfortunately it was just a matter of filing it. So the defense has not been prejudiced in any way that the state has filed it late, but I do agree that I did miss the 10-day deadline, but they have had those reports for over 10 months.
All right, Mr. Gaelic Brown, with respect to the state's argument as to whether or not you were aware of them going to file this Williams rule, whether or not you received the documentation, the reports outlining the particularities of the Williams rule notice, is that correct?
With respect to the point that we received 2 police reports that are referenced in the motion, that Ms. Garcia is correct. We received those in discovery some time ago. However, of course, the notice requirement of a Williams rule motion goes beyond just receiving police reports. The state has to state specifically what the evidence is, what they're going to be, what purpose they're going to be using it for at a trial, what witnesses they may be calling to elicit that evidence. And so there's a difference between getting police reports that would, potentially be used in Williams rule evidence and then filing the motion itself. So there is a 10-day requirement. I don't think that's been met here.
All right, but was the defense on notice that the state was going to be filing this notice of Williams rule prior to the actual filing?
I did have a conversation with Ms. Garcia, certainly on Tuesday, and she said she would be filing it. I think she had alluded in the past as well, and mentioned potentially in court as well that she would be filing a Williams rule motion. But that's, again, very different from actually receiving a motion itself and seeing the state try to lay out their case for what the evidence would be and what they would be relying on.
All right, so let me announce, first of all, the reasons why I'm going to rule the way I'm ruling. Number one, this matter was filed on October 8th, 2019, more than 2 years ago. The court, as far back as May of this year, said no further continuances. And since that time, we have had continuances. One was from the court, but specifically on November 23rd, again, I said no further continuances. I am not happy with the fact that the defense has filed a motion to suppress as it relates to a statement. The state's argument is that they need time to respond. The court does not need a response. The court knows the law and will listen to whatever evidence is presented during the course of that motion to suppress hearing. As it relates to the Williams rule filing within the 10-day period, the court does have the discretion based upon what I hear from both sides as to whether or not there is any prejudice to the defense with regards to the actual filing. The court finds there is no prejudice, that the defendant was on notice as far back, I believe, as early of 2021. As it relates to the documentation being presented, the communications between the state and the defense as it relates to their intent to utilize this Williams rule evidence. So the state and or the defense motion to continue this matter is denied. This was specially set. I cleared the calendar. I made sure I accommodated everyone else so that this case would go to trial on Monday. What we will do is, as soon as my calendar is over, we will commence with the motion to suppress. And I will state on the record, as of now, I've reviewed the defendant's motion to suppress. I do find it to be legally sufficient. So that prong is, we have passed that prong. So I will be ready to hear the motion to suppress right after the calendar. How many pages do we have on Monday? 37. I would say we should be hopefully ready by 10:30 to begin with the motion to suppress. And if need be, we will pick a jury by, I guess we'll start picking around 1:30. Okay?
Judge, a couple of clarifications. With respect to your ruling as to the Williams rule motion, so I just received this motion a couple of days ago, so I would like to file a written response to that motion, because there are additional issues here in addition to the notice issue.
Okay. Well, it's not a motion, it's actually just a notice, but with respect to the notice, you want to file some type of response to the notice, which certainly you're able to do. And we will address it on Monday morning, but we will be going to trial next week.
Understood, Judge. In this case, I guess would be first in line for trial on Monday.
That has always been the intention of the court. That's why we specially set it for December 6th.
Understood, Judge.
Okay?
Your Honor, just to clarify, you said that we would litigate the motion to suppress on Monday after calendar?
Correct.
Okay, and that's approximately 10:30 on Monday?
I would think. I can't tell you exactly, but that's going to be my goal. It's around 10:30.
Yes, Your Honor. When
Start calendar at 9. Keeping in mind, but folks, we do start at 9 at 9:30.
Yes, Judge. When will we be litigating the Williams Rule notice?
We can do that shortly thereafter. I don't think that will take too much time.
Okay.
All right.
And Judge, just to make sure the defense is aware, that means that we will not be making available Detective Rosh or Lieutenant Rosh, who's over in Alabama for the deposition. I think we set it for Monday at 2 p.m. So that's not going to take place, and we are going to be calling him in the case in chief.
Okay. Thank you.
Thank you, Judge.
All right. The next case that has been placed on the calendar for status is on page 6. Michael Nowak. If counsel can please state your names for the record.
Good morning, Your Honor. David Terrace on behalf of the defendant, Michael Nowak.
Thank you.
Good morning, Judge Nicole Garcia, on behalf of the state.
Thank you. So this case was on for status, and I was checking with the court file and the court clerk, and we were a little unsure as to what the status was about. I know that there was an issue with regards to the stay-away order. The last time this was up, I think there was a stay-away order given to the defendant. So maybe you can give me some additional information either side.
Yeah, yes, Judge. Sorry. Yeah, everything with the stay-away order was handled at the last hearing. This is the first time up since the defense has received discovery. So I'm not entirely sure why this was special set for today, but we're going to be requesting a defense motion for a continuance. My office has discussed that with the state. They have no objection. We're in the process now of having reviewed discovery, working out one other discovery matter, which the state has already discussed as well, regarding body cam and taking depositions.
That's correct, Your Honor.
Well, it's a bit odd that the case was set on a status and we never got a trial date. So that's why I'm. All right, that is bizarre. So at juncture, we will go ahead. We'll make this a defense continuance. We'll give it a trial date. Or let me just ask you this: is this going to be? Is this going to take some time for the purposes of discovery? I don't know all the extent of the discovery. Why she put it on a status queue instead of a trial queue?
I mean, yes, Judge. There's going to be a significant amount of depositions, and I'm sure discovery discussions and mitigation. So I don't believe it needs to be set for any special status. It's just going to take some time to work up our defense and negotiate with the state. It's the first time up.
Okay. State agree with that?
Yes, Your Honor.
All right. So what we'll do is we'll just put it on for report instead of a trial.
Y'all called it.
We are in December, January. How does February?
Lord.
What do we got? February 15th for report. Both sides okay with that?
Yes, Your Honor.
Yeah, absolutely, Your Honor. Thank you very much.
Okay. Thank you both. Take care.
You guys called it. You called it. I think continuance 1 yesterday when I did the poll. And did you notice that he said because there's a lot of discovery and what did he say? Mitigation as well as depositions that will be happening? There's a plea deal coming. I already know. If you watch my video on David Torres, who is Brother Polight's attorney, he covers cases like this, specifically these kind of cases, child pornography, things like that. And he always ends in a settlement of some form. His job, he's like, usually with the cases that he's covered, they always find a way to get a deal for a lesser charge. Sometimes they may not even go to jail, but all of them do become registered sex offenders. So that's not something you can run away from. I knew it last night when I saw him post. I said he knows that there's going to be a continuance, and that is exactly what happened. So you guys are right. You think he's going to plead out? Let me read some of these comments. There's not going to be a trial because you see, even the judge said, why didn't we just schedule a trial date? Now that 10 days makes sense. It was entered as a status hearing, reporting hearing, and it says 10 days prior to trial because it caught the judge off guard, if you didn't notice, where he said, why didn't we set a trial date? What is this reporting about? Is there an issue with the stay away order? So there's no issue with the stay away order. Clearly, he's still complying with that. Somebody asked, was the mother not going to testify anymore? I didn't see that. I think that she will still be testifying, and you heard them say that they have that body cam. Now, he has his court date. If you guys heard, that's funny. Lesser charge. That's funny. The next trial date, and then that is not even a trial date. I think that they said, what is that? That's going to be another status hearing in February. We just watched Grandmaster Jay's case day before yesterday, and his case, the next day is February. I think they said February 15th. That's the day after Valentine's Day. And this incident occurred in February. So about 1 year after, they're going to do like a reporting hearing. Now, if by the time we get to this reporting hearing in February, that David Torres has the same song and dance, it is very clear that there is no defense. I still stand on there is no defense because he didn't even have as much fire as he had in that first hearing. If you go back and watch the first appearance of David Torres, he had a little fire in him. Today, he was, Your Honor, we spoke to the other side. She has no problem with that. So let's go ahead and schedule that date. Even when the judge is asking about why is this not a trial date? Why did we just put this on the calendar? Issa, you think a plea agreement? Any plea deal will involve at least 10 years in prison. You think so, Johnny? Because I'm 50-50. You know, when we look at just historically, when it comes to predators, sometimes they get like 2 years, 3 years. I mean, it all depends on your negotiations, how they can negotiate. He ready to negotiate. He didn't use the word negotiate, but he used the word mitigate. There's a lot of mitigation happening. So they've been talking behind the scenes, and I'm thinking in February that they're going to have a deal on the table or something. Usually things like this, it could take really long, actually. But it seems that the pace of this judge is faster than normal because sometimes they schedule it out March, April, May. So this pace has been going fast. But on the other side, you have the defense saying that I'm not ready. And you know, part of the criminal justice system is for you to be able to fully give your defense. So if your defense attorney is continuously saying that they don't have all of the information or there's mitigation, they need more time, then the judge will give them more time. But we saw from the earlier hearing before Polight's case that this judge does not play, because in that first case, he said, I've already given enough extensions. When I came here last time, I told you that we won't be doing any more extensions. So I'm going to deny it. You can't get 2 to 3 years when DNA is involved. Well, I hope you're right, honestly. I wouldn't argue with you. He did mention body cam footage as part of the discovery.
Peace community, peace community. Shout out to Snatch Investigations on his good work. Salute to you on this. Better yet, let me just give you applaud and salute to everybody that's rocking with us right now. If you're new and if you're a part of the community, salute to you and salute to Snatch Investigations. Make sure you are subscribing to Snatch Investigations as I've been moving my content around, making sure that I give us global and local and different, different categories of content. Most definitely when it comes to this case, I will be checking in with Angie Snatch from Snatch Investigations. So make sure you subscribe to Snatch Investigations. We was doing a little back and forth with the emails with when it was coming to the superseding indictment. You know what I mean? That's when we was most definitely doing the cases on R. Kelly. So salute to her. Like you said, this judge is not playing. We heard that. We did. You said here mitigating, but we did hear some negotiation business. Sound like negotiations. You know what I'm saying? We did see somebody in her chat saying that if he did get the plea, then he could get like 10 years in jail. Could be up in the air with that. You know, it's a lot of things. You know, it's a little too early for us to all say. We do know that another case court hearing is coming up in February. Like she said, it's just a quick little case, though. It's not. It's like a status case or whatever the case may be. So yeah, I did see like I said, I did see David Torres too being a little more pulled back, you know what I mean, not as aggressive as he was for proving his case and his points like he was in the pretrial hearing. So I do agree with Angie on that. I do agree with her on that. But, you know, I look forward to seeing what you got to say, what y'all thoughts are on this whole situation, how y'all feel about Brother Polight, the whole damn situation. I look forward to seeing and hearing exactly what y'all going to be saying in the comments. Yeah, man, it's just a tragic situation, man, so far, man. You know, what's really just messed up, though, is that after him being accused and being arrested, right, then he just goes to Instagram and then he makes these videos and stuff, but no video shows no empathy, no nothing like that. You know what I'm saying? Not to say that if he shows empathy, it admits his guilt. You know what I mean? But, you know, it's just to say, like, I'm innocent of this, but, you know, I most definitely, my heart goes out to that child, and I do hope that that child do get justice. You know what I'm saying? That's what innocent person could say that. You know what I mean? So we've watched many people come up in front of those cameras, big famous people, more famous than this guy could ever be, and they say, I ain't do it, I'm innocent. I'm free. I'm innocent. You know what I mean? So sometimes I guess that's part that rub people wrong. So, you know, like I said, salute to all of y'all for all y'all loving y'all support, for all y'all remembering that we are one love, one voice, one community. Make sure everybody is subscribing to the channel. Turn the notification bells on and make sure you're notified when we drop new content. So I most definitely salute to all of you. Appreciate all your love. Make sure you're all going to check out my website, www.don'thidetheplug.com, and going to get one of your dope snapbacks, strapbacks, different hats, shirts, and merchandise. So make sure you're checking us out and supporting the community. We appreciate all, and I mean all, of your love and support. Appreciate you.
Video is sponsored by our first ever sponsor, Don't Hide the Plug. Don't Hide the Plug is an apparel company co-founded by two brothers from Flatbush, Tafari and Rossi Harper. Now, these two black brothers have created an amazing, inspiring, high-quality brand. Now, you see on Infominds, a lot of our content is New York-based. We love New York, so it's only fitting that we partner up with a New York-based brand, Don't Hide the Plug. Now, they got some fire fitted hats, hoodies, T-shirts, and I'm feeling the old New York design with the bridge logo. They got the clout joints, the dad hats, and you can also have them delivered to you in the resealable merch by the pound bags too. Now, mind you, they might be New York based, but their apparel is for everyone, whether you're from New York, Miami, Texas, Chicago. It's a grassroots movement. Get in tune. And they offer free shipping on all domestic orders of $75 or more. But if you enter the exclusive Infominds promo code, you'll get an additional 10% off at checkout. You already know I ordered my package. My package is on its way. So I'll be wearing and showcasing the Don't Hide the Plug apparel.